I'm pleased to rise today to speak on Bill 17, a very important bill, one to amend the Essential Services Act. And, Madam Speaker, I have nursing homes in my riding. I've got one right in my own community. I know the people that work there. I know some of the residents that are there. And there's no question, I don't think, by anybody in this chamber, or anybody that works in that sector or the public at large that has family in there, that those that do that job every day, it is a tough job. There's no question. You know, when you talk about resident assistants, licensed practical nurses, registered nurses, administrators, housekeepers, cooks, they all play critical roles to keep our seniors safe and comfortable. I'll just give you an example of one home. There's approximately 40 residents in one wing of that facility that would have, on a good day, about 6 resident attendants or assistants that would look after them. That's one resident assistant per 6 seniors. And that's during the best of times. If you look at, the midnight shift, sometimes that number goes up to 1 resident assistant looking after as many as 20 seniors. We all know there's major issues in our nursing homes with hours of care, with the workload, with the stress. Many of them are overworked, they're understaffed. That is a fundamental issue that has to be fixed in our nursing homes. Because there's 2 downsides to the situation in nursing homes. One is the workers themselves. We talked to WorkSafe NB, and they made it clear to us that the largest amount of claims, now think of this, the largest amount of claims in WorkSafe NB, you know where it comes from? It comes from the healthcare sector. And part of that, in that scope or in that idea, is nursing homes. They play a significant factor. So that means workers that are working in nursing homes have higher amounts of claims of injury than people in other sectors, other areas of the public sector. So you've got nursing home workers that are overworked, they're suffering from injuries on the job, they have to deal sometimes with violent episodes, and all, in many cases, simply because there's not enough staff. I believe there's 2 issues with that. I believe there's an issue of government resources delivered to these areas, but I think it's almost like a pandemic that's across the province. I mean, you can pick any sector and you're seeing a massive labor shortage. We're seeing more and more people not going into the field, and the ones that are in it are stressed out, overworked, and some of them unfortunately are leaving. Now, I'm not convinced that this bill is going to help that. I'm not. But I'm equally convinced that this bill is not going to hurt that either. I think this bill as it is a wash. I believe the solution to the issues in nursing homes has to come from government, it has to come from unions, it has to come from managers, administrators, and more importantly, employees who work that system every day. That's where the solutions are going to come from. You can't find solutions fighting with unions and governments in the media. You can't find solutions through just protesting. You have to find solutions through the people that are working it every single day. And I know there's a huge disconnect. There's a huge disconnect between government and unions. There's even a disconnect between union leadership and union members. There's disconnections all over the place. But we have to come together and find the answers to these problems, to give the workers the assistance they need, to give the workers the extra help that they need, so that residents can be looked after. Now, Madam Speaker, in this bill, there's 2 parts to it. The first talks about designating essential workers. Now, for me, that's a no-brainer. I mean, we have hospitals, we have emergency services, all of these things require a designation to be able to perform their duties and make sure the public is protected and safe. We cannot, as legislators, none of us in here, I would hope, would vote to destroy that. Because without specific legislation, in essence, when January 2nd comes down, nursing home workers and nurses alike could potentially walk off the job. Now, it's never happened, and I would hope that with or without the bill that wouldn't happen, but I feel much better knowing that it's legislated so that it can't happen. So it is important. It's very important. It's critical that we have that piece of legislation in here. My concern is with 4 parties in this House, is amendments are going to be kicked out, they're going to be discussed, they're going to be turned down, voted up, voted down, and by the time this bill comes around, my concern is we don't have resolution to this. And the worst case scenario is come January 3rd, we have a complete collapse of our workers leaving the nursing homes. We can't let that happen. I will not let that happen. My team will not let that happen. So there's balance. The second part of the bill is where it obviously gets a little bit dicier. The Bill 17, which talks about binding arbitration. We noticed a very significant part of that bill which mirrors other provinces, and that's the key thing here. We're not reinventing the wheel here. Other provinces have introduced a bill regarding this. I believe Nova Scotia, Ontario, Saskatchewan, to name a few, have brought these bills in long ago, years ago. And when you look at the overall evidence of those bills in those other provinces, the sky didn't fall. And this is what perplexes me, I guess, the most about this contentious bill. You've got government on one hand that's digging their heels in, that somehow they think that through this bill, the arbitrator now in his decisions are going to favor the government. And then you've got the union leadership on the other side. They're claiming that the sky is going to fall, that now the arbitrator is going to side with the government on issues. And I, frankly, don't think either of that is going to happen. When you look at other provinces that has this bill in place, you can clearly see that that has not been the case, Madam Speaker. Just for example, you can look at Ontario when they lay out the criteria of their ability to attract employers. The City of Toronto, labor disputes, the Resolution Act set in 2002. It clearly showed that indeed it fell on the side of the workers, even with that legislation in. I can show you case after case after case with this legislation that is similar, with the legislation in Ontario that's similar to what is being brought forward here, case after case of arbitrators ruling in favor of unions, giving them the increase that they need because the arbitrator looks at all the factors, as the bill says. So I want to read one section here. For example, the Mon Cheng Home for the Aged in 2016, the decision says the application legislation was the Hospital Labor Disputes Arbitration Act. The union proposed 1.4% per year. The employer, a nursing home, was opposed to any wage increase. Well, the arbitrator in that ruling in 2016 awarded 1.4% per year. The Toronto Civic Employees Union versus the City of Toronto in 2002 decision. The application legislation was the City of Toronto Labor Disputes Resolution Act 2002, which went to the union, the Back to Work legislation. In that case, the union proposed wages increase of 3.5% in year 1 and year 2, and 3.25% in year 3. The city proposed 3% each year. The arbitrator awarded annual wage increase of 3%. In rendering the decision on wages, the arbitrator explained that he must also turn his mind to the overall fairness and equity of the decision. The Norfolk County and Health, Office and Professional Employees, the 2017 decision. The application legislation was the Hospital Labor Disputes Arbitration Act. In that case, the employer was the municipality that operated the not-for-profit long-term care home. The following wage increases were awarded by the arbitrator. July 1st, 2016, 2%. July 1st, 2017, 2%. July 1st, 2018, 1%. 19, 1%. July 19, 1%. January 2020, 1%. Over and over and over. We can look again. The Niagara Regional Service Board, Police Services Board, in 1997 decision. The application was legislated under the Police Services Act, and the arbitrator again awarded wages increase of 1% in 96 and 97. So again, over and over we see that despite this legislation, the arbitrator is still unfettered to make his or her decision in the best interest of fairness and equity. And I don't see how this bill is going to take away from that. Well, if you look at the bill itself, it very clearly says that the arbitrator shall consider. That's important. That is critical to note. It does not box the arbitrator that he or she must do this or that. It says he shall consider. Shall consider. Well, Madam Speaker, I've considered lots of things in my life. I considered skydiving. Chose not to do it. I mean, I've sat in this house and I've listened to the member from Miramichi Bay Neguac on her usual rants. I've considered jumping out the window just so I don't have to listen to her, but I've not done it. And the whole point of the legislation is what it says. You shall consider. It means the arbitrator has to consider the factors that are listed. Now, there is, Madam Speaker, one important clause that was left out in the original bill. The important clause was that it left out all other relevant factors. You see, if you look at Ontario's bill, it has that in there. So Ontario lists out several things that the arbitrator must consider. But with that, it also includes in there that the arbitrator must also consider other relevant factors. That was missing in this original bill. Now, we've had many discussions with government. We've had very productive discussions with the Minister of Social Development and the Premier on that issue. And I'm pleased to know that in the next coming days that there will be an amendment to make sure that that is included in there as it is in other provinces. And that, again, will lend more weight to the opportunity of the arbitrator to make a fair and equitable decision. I mean, I would not, nor would my colleagues, vote in any way to create a piece of legislation that's going to tip that balance. The courts wouldn't even allow it if it was tried. This is simply an opportunity for the arbitrator to be able to look at all relevant factors, specific factors that is laid out in the bill, and then render a decision that is fair and equitable. Now, one thing I will say, I think the opposition has a very valid point. I think it's going to be very difficult for the arbitrator to be able to consider ability to pay. I say that simply because, as a province, we bring in, roughly $9 billion in annual revenue every year. So how can an arbitrator figure out where that $9 billion go and what percentage of it would go to raise some of these workers' increases in wages? So I agree. There's a valid point in that. That, the ability to pay is very nebulous. It's very out there in how it's defined. But again, if you define ability to pay in legislation, then you move away from what is fair and equitable. So it has to be kind of nebulous. So the arbitrator, again, has that opportunity to look at all sides of the equation and find in the middle ground what is fair and equitable. The message, Madam Speaker, that I want to lay out today, I don't believe the sky will fall if this bill passes. I believe the sky will fall if the first part of that bill doesn't pass. Then we're going to be in a crisis. And I cannot, and my members, my caucus cannot sit back and let that happen. So we have to be part of the solution. We have to be part of the process to make sure that at the end of the day, this bill is fair, it's balanced, and again, it's my personal opinion. I believe history will prove me correct. When at the end of the day, should this go to arbitration, that the arbitrator's still going to have all the tools and avenue he or she needs to make a fair and equitable decision. It's up to the unions to put the best argument forward. It's up to government to put their best argument forward. And it's up to the arbitrator in the middle to find a fair and equitable decision in that process. So, Madam Speaker, so long as the amendment that the government is looking to bring forward here in the next 2 days does come forward, We will be supporting the bill, and we will do so, again, with the understanding that this bill, at the end of the day, is not going to hinder an arbitrator from a fair and equitable ruling. I don't think, again, government should take a whole lot of stock that this is somehow going to lower the percentage, because I'm not convinced of that. Sure, it's not proven in other jurisdictions. But I think history will prove me right when I say that at the end of the day, the arbitrator will still do what the arbitrator is going to do in rendering a fair and equitable decision for our nursing home workers. And again, putting the arbitrator aside, Madam Speaker, we cannot, as politicians, as elected officials, as people who have a very serious job to do here, we cannot allow these things and the politics that's played in it to not deal with the issues of the working conditions of the staff at these nursing homes. Because that doesn't just affect the employees, Madam Speaker, that affects the residents. And if employees are so overworked, if they're so understaffed that they can't check on bed sores, and they, because time is just of the essence, and we talk about the hours of care that goes with it. If it needs to be increased, then it needs to be increased, and we have to do what we can. I'm glad that the Minister of Post-Secondary Education, Training and Labor is starting to work now towards bridging that gap to get those nurses in here. I think that has to continue. And Madam Speaker, I can tell you, I've talked to immigration consultants, and I knew one specifically, and he would bring in nurses from the Philippines, and he would put them in Subway to work. Or he'd put them in, McDonald's or Burger King to work. And I'm thinking, here we have a massive nursing shortage, and we have nurses from other countries coming in here, and they're working at fast food chains. That doesn't make sense to me. So I hope that that can be rectified as well. So when you have nurses from other areas coming in with degrees from those areas, there may be some standards in Canada, I understand, that have to be met. And if that means some extra training, if that means, an extra 6 months to a year to make sure they understand how our system works here, I'm perfectly in line with that. We do not want to compromise our standards. But Madam Speaker, we have got to open the doors to allow not just nurses here, but nurses from around the world to come and practice here. So I hope the Minister of Post-Secondary Education, Training and Labor, who looks after this file, is serious about that and is working towards that. And we'll be watching that closely and offering any support we can to fix that nursing shortage. But at the end of the day, Madam Speaker, this is an important bill, especially the first part. And like I said, we can't allow a strike to happen where you have people walking off the job in droves. You need it legislated. You need it found and fixed in law, and that's important and that's critical. So again, I look forward to the Economic Committee on this issue and asking some questions to get a little deeper into the meat of it and going from there. Thank you, Madam Speaker.